So the Fifth Circuit Court of Appeals just heard oral arguments in the Texas Suppressor Freedom case, and that case aims to stop the NFA and ATF regulation of suppressors. So we need to talk about what just happened. Now, real quick before we jump into this video, I want to ask you guys for a favor. Looking at my analytics, about 60% of all viewers here on the channel are actually not subscribed to the channel. So if you want to support this content, if you want this content to get out to more people, to inform more people, if you enjoy this and you want to support the channel for free, one of the best ways to do that is just simply clicking the subscribe button. That does help this channel, helps it to grow, and helps these videos to get out to more people. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we need to talk about a hearing that just took place in relation to the state of Texas and their suppressor freedom lawsuit and the law that they put in place. This law passed by Texas, and now the subsequent lawsuit that's going on essentially aims to eliminate the NFA and ATF's regulation of made in Texas suppressors. The case we're going to be discussing in this video is called Paxton versus Dettelbach. Now, for those not aware, this lawsuit arises out of Texas House Bill 957. HB 957 exempted silencers which are manufactured in Texas and which remain in Texas from federal firearms laws and regulations, which include the federal registration requirements under the NFA. The claim behind this law is that since these items are made and sold exclusively within the state, and they're made potentially out of parts exclusively within the state of Texas, they do not fall under interstate commerce, and therefore they fall outside the purview and regulation by the ATF. After Texas passed that law, the ATF then sent out warning letters, essentially threatening everyone in Texas that they would still enforce the NFA and GCA's requirements and regulations against these types of suppressors. Now, Texas, along with individual plaintiffs, filed a lawsuit against the federal government. This case was then submitted to the federal court, and on cross motions for summary judgment, the lower court ruled in favor of the federal government and ruled in favor of the ATF. The court ruled in favor of the ATF under the rationale that the plaintiffs lack standing to bring this lawsuit. Now, under the concept of standing, legal actions cannot be brought simply on the grounds that an individual or a group is just generally displeased with what the federal government is doing. Federal courts only have constitutional authority to resolve actual disputes. Now, standing has three basic requirements, one of the first ones being that there needs to be a concrete injury in fact. On review, the judge here found that the plaintiffs have not suffered an injury in fact, and therefore they had no standing to proceed forward with this case, and the case was dismissed. Here, the judge essentially stated that the individual plaintiffs would have to allege that either they possessed an illegal silencer, that they've engaged in this conduct, and they've done something that's prohibited and potentially they can be convicted of, or in some way they would have to go through the process, go through the application process, be subject to the process, either be approved or denied, and because of them going through that process, maybe they could claim an injury. But they could not just simply, write these declarations saying that they intend to engage in this conduct. The lower court judge there said that they would have to present some form of evidence, something more than just showing a general intent to make made in Texas suppressors. Now, in response, the state of Texas then filed an appeal up to the Fifth Circuit, and they're seeking a reversal of that lower court decision. The ATF responded to this appeal and argued to the Fifth Circuit that they should, in fact, affirm what the lower court said, uphold that dismissal. Now, the ATF also argued that under the Tax Anti-Injunction Act, or the AIA, this lawsuit was improper since it would result in the avoidance of paying a required tax under the NFA. Then the ATF argued that the Second Amendment is not implicated at all when it comes to suppressors. And this week, this case was argued in front of a three-judge panel in the Fifth Circuit. The panel is three conservative appointees, two of which were actually on the Rahimi case. If you're not familiar with the Rahimi case, that dealt with domestic violence restraining orders under federal law and the prohibition of being in possession of firearms if you're subject to domestic violence restraining orders. That was an issue that was ruled in favor of the Second Amendment using the Bruin analysis. And recently, that case has actually been heard in front of the Supreme Court of the United States and is going to be decided by the Supreme Court applying Bruin when it comes to those federal prohibitions. So that's an important case. It's probably going to be the next big Second Amendment case applying Bruin when it comes to that analysis. And that lower court decision, which used Bruin against this type of federal restriction, came from two of the judges here on this panel. It came from Corey Wilson, who wrote the majority opinion in that Rahimi case, and then also Edith Jones was on that panel as well. And so two of those judges are also on this panel, along with one other judge. So the panel is probably one of the more favorable panels that you can get coming out of the Fifth Circuit, but I would say that the arguments here that took place didn't really fully use those judges to their favor. It's one of those unfortunate things where it's, once we got one of the best panels we could ever get, I feel like the opportunity was squandered a little bit by some of the arguments that happened. Now, first up, the attorney for the individual plaintiffs out of Texas spoke and was trying to put forward their belief that these types of suppressors are necessary for self-defense, that they are necessary in the Second Amendment to engage in self-defense also within the home, which is one of those core aspects of the Second Amendment. He stated that the plaintiffs wish to make these types of devices, and there's no dispute that they intend to make them within their home, and that they would probably and most likely face serious criminal penalties if they engage in this conduct that they stated in their declarations that they intend to engage in. But there was some pushback from the judges on the panel where they talked about, do you have to allege something more specific than just a general intent to engage in this conduct? Now, one of the judges, I believe it was Judge Clement, talked about, would they need to allege more than just a general intent in their declaration? Would they have to maybe allege that, hey, we bought a 3D printer, that we have the general skill and know-how to make these types of suppressors, we intend to purchase these items from these specific locations, and we're targeting, wanting to get these types of items from this, or these parts from this specific company? Would you have to allege more, skill or items or some other additional conduct than just a general intent? Towards the end, there was a great rebuttal to this, that, the lower court here dismissed this case before any additional factual record could actually be developed about what the intent of these individuals was, what they intended to engage in, what type of items they had, what type of skill they have. The case was dismissed before that type of factual record could really be developed. Now, one of the major sticking points during this argument was the actual process to register or go through the application process to register these items with the ATF. A lot of the judges seem to be pointing to the fact that these individuals here have never applied, they haven't gone through the process, and would them actually going through the process cure this type of injury? Would they be able to claim there's an injury if they go through the process like the lower court claimed? Now, I don't think that there was a lot of great pushback from the state of Texas representatives or even the individual representatives about having to subject themselves to an improper process or an unconstitutional process. I think they could have used Bruin a lot to challenge this process. At one point, I believe it was Edith Jones who is, I think, trying to bring up this argument that was brought by the state of Texas and the individual plaintiffs about Bruin and being able to challenge these types of unconstitutional processes. It was brought up in their briefs, and I think she was trying to bring along those type of arguments during the oral arguments. But they kind of skirted away from that. So I think that could have been a stronger section where we could have brought that and really challenged, hey, we don't need to subject ourselves to an unconstitutional process. That's something that's up for challenge. And saying that we have to go through the process, potentially send photos or do all this before we suffer an injury, in the constitutional context is just not accurate. But one of the good things is when it came to the government's time to speak during the oral arguments, I think that's when the conservative nature of these judges really came out in their pro-2A stance. There was a lot of very interesting discussion by a couple of these judges talking about how can the government here, the ATF, say that these individuals need to subject themselves to this process, potentially send photos that go to a database that the ATF can then use against these individuals to try to convict them and make them criminals. And then the ATF's representative said, well, we don't keep a database. We will, under this code section, we say that we're not going to actually go after people. But then the judges here, both of them, push back against that, talking about, well, the government says that all the time, but they use their databases, they keep databases that they're not supposed to keep, and then they use a lot of this type of information against individuals, and they brought up like the IRS and the ATF as well doing those types of actions. So that was pretty funny, and that's when I think the conservative nature of the judges really came out, pushing back against the federal government. But one of the things that the arguments kept coming back to was maybe one of the easiest ways to cure this whole claim that there is no injury would be these individuals actually going through the application process. Maybe going through the application process as far as the ATF then saying, hey, we need you to send pictures or more additional information on the type of suppressors you want to make. And these individuals saying, no, we're not going to give you any additional information. That's an injury. We've opened the door for the application process. Now, I think it's a little bit concerning that the judges were opening up that door. And even at one point, they asked the ATF, are you conceding that that would cure this whole injury issue? And the ATF, of course, was not willing to concede that. But here the judges are almost signaling that, hey, that would cure the injury. So I think at the very least, the main takeaway of this, if you're listening to these arguments, was that there is going to be a strong possibility and probability that the court will in fact rule that the lower court was correct to find that there was no standing. However, I will say that if this Fifth Circuit 3-judge panel rules that way, I think there's going to be a very clear opinion from this panel talking about how this standing issue can be cured, how they believe that going through the application process, at least in a limited way, would cure that injury and will allow this case to proceed forward. So definitely a very important case going forward and something we're gonna have to watch to see how this 3-judge panel rules. But of course, if we get any more information, if anything else develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.